So welcome everybody to the Atlanta Hypersomnia Support Group meeting today. We're so very excited to have a special guest here today. Normally we start these meetings by saying what's said in this meeting needs to stay in this meeting, but today we are videoing our special guest presentation. Hello, come on in. And Q&A session. None of you will be on the video, just Attorney Burgess will be, but when you ask questions, she is going to repeat your question and then answer your question, and that's so our folks at home can hear what your question was and hear the answer. So we just want to welcome you all here today. Just a little bit about Attorney Anjel Burgess here. She boasts impressive academic credentials and has developed a wealth of knowledge in the area of disability law. She has received her BA from North Carolina State University and an MA from the University of South Florida, and in 2008 she got her JD from Georgia State University, my alma mater. Prior to joining Burgess and Christensen, Attorney Burgess practiced civil litigation with an emphasis on insurance defense, so she kind of knows the other side, which is really good. Known for her excellence in representation for the past 5 years, she has practiced exclusively Social Security disability law for adults and children, as well as the ancillary areas of guardianship and special needs trusts. She brings to the Social Security disability practice her compassion, which she very much is compassionate, y'all, quest for justice, enthusiasm, desire to help others, and by doing so, she's been able to make a positive difference in the daily lives of people who need help the most. So we're really pleased to present Attorney Anjel Burgess today.
Thank you very much. I'm very happy to be here. What I wanted to do today was start off telling you just a little bit more about myself and then going into an overview of the Social Security disability process and then answering any questions that you all may have. My office is located in Marietta, Georgia. My law partner and I, his name is Lawrence Christensen, we help individuals across the state of Georgia, but our emphasis is really on Metro Atlanta. So for adults and children that are either unable to work as adults because of any conditions that they may have, or children who are not able to perform at an age-appropriate level, we help to get disability benefits. So the Social Security disability process is a baffling one at best. It can be very confusing. It is a very long process, and attorneys come and help people to navigate their way through the process. At our firm specifically, we help people from the very beginning who need to file an application for disability, and we also have clients that come to us at various stages of the process. Some people have filed their own application. Some people have a hearing next week in front of a judge. Some people have been denied, but at any point we're able to step in and help out. Social Security itself is a process designed to provide some financial and health insurance for people who are unable to work. My focus today is going to be on adults because you're all adults sitting here, but if anyone has specific questions about children, I can talk about the requirements for children as well. The process itself tends to be a three-step process for most people. Most people will file an initial application. At the initial application level, what happens is Social Security requests medical records, they get information from you about your work history, they get input from you about just your day-to-day activities, what you're able to do, and they also get some input from a third person, someone, a spouse or a friend, who gives their perspective as to what your life is like with your impairment. So Social Security will compile all of that information, and they have doctors who will review the medical records and give their opinion as to what they think you can do. Once that opinion is reviewed, typically a decision is made as to whether or not you meet the criteria for being disabled. And most people, being 65% or so, will get denied at an initial application level. After you're denied at initial, then you'll have to file an appeal if you want to continue with the process. So the appeal state is called reconsideration. And at that point, you are asking Social Security to take another look at your medical and or any other information and make a fresh determination as to whether or not they think you're able to work. At reconsideration, approximately 90% of people are denied. And so you have to move on to step 3 of the process, which is to request a hearing in front of an administrative law judge. Now, this is the stage in the process where most people who get approved will get their approval. And that process involves, in most cases, going to a hearing in front of a judge and presenting your case. The important thing about going in front of a judge is you get the face-to-face interaction with the judge. The judge gets to observe your demeanor. The judge gets to ask you questions. No one gets to ask you questions earlier on in the process. So it's really a vital step in getting a level of understanding as to whether or not you can work. Now, there are levels beyond the hearing level. If you're denied, you can appeal to the appeals council. But most people who do get approved go to step 3. They go to a judge, and the judge will find that they are disabled. In terms of specific conditions, you can be disabled with any condition. The condition just has to be severe. It has to last or be expected to last a year or more, and it has to keep you from being able to work. And Social Security does allow some people to work part-time. You can technically engage in part-time work and be disabled, but they're concerned with full-time employment on a continuous basis. So for conditions such as hypersomnia, many people find that their difficulties with working kind of present themselves, and they try to hang on to the job and work through their symptoms as best they can, and then they get to the place where it's just no longer feasible. Or sometimes the employer gets to that place first and says, I'm sorry, this is just not going to work. So it's important to know what your options are, because Social Security disability should be your last resort. There are other programs that are available that a lot of people don't know about through employers and sometimes privately that I really want to make sure that you all are aware of. If you're working and you're having difficulties performing your job, a lot of employers have short-term disability options available, and also long-term disability options available as well. There are also private companies. So if your employer does not offer short-term or long-term disability, you may want to consider looking into private insurance, which can offer you similar benefits. But ideally, what would happen if I could plan someone's future who will ultimately be unable to work, the plan that I would design for them would be one which protects them financially before they have to apply for disability. And that would be to apply for short-term disability and then move into long-term disability, but at the same time apply for Social Security disability. Because the Social Security disability process, those 3 steps that I just talked about, tend to take 2 to even 3 years to get through. And that's a long time to go without any income. So to the extent that you can protect yourself with some of the other options, that is certainly the way that you would want to go. For some people, they're not fortunate enough to be able to use short-term or long-term disability, and sometimes people are terminated and they have to rely on unemployment. Now, unemployment can be a little tricky because when you file for unemployment, you are asserting that you are able, ready, willing to work. When you apply for Social Security disability, on the other hand, what you're saying is I'm not able to work. So there is some conflict there with the receipt of Social Security, disability, and unemployment benefits. And we can talk about those conflicts specifically if any of you all have any questions. But that is an option that a lot of people are forced to, unfortunately, pursue, is unemployment, to be able to get some income. So what I'd like to do at this time, before I dive even further into things, is open up the floor for any questions that you all may have about disability, the process. Is anyone?
55% of people will get denied initially.
Yes.
Is that with and without help from a lawyer?
Yes.
Can you repeat the question, please?
Oh, yes, I'm sorry. The question was, earlier I had stated that approximately 65% of people will be denied at the initial application level. And the question was, is that 65% with or without a lawyer? And that is with a lawyer. So regardless as to whether you're represented, the odds are 65% of people that eventually get approved will be denied at initial. And initial is the medical records review process, initial and reconsideration. So Social Security is doing their own internal investigation into what your medical records or any other records, you may have employment records, school records, but what those records say about your ability to work. Yes?
Did you get to step 3 before a judge, and you still ask the questions at step 3, would you actually have a lawyer with you?
The question is, if you get to step 3 of the process, which is requesting a hearing in front of a judge, would you have a lawyer with you? My recommendation is absolutely. In any sort of legal proceeding that you have to go in front of a judge, you want to be represented by an attorney. The judge has to use Social Security's rules and regulations to make a decision about whether or not you're disabled. So you want to have someone representing you that knows what those rules and regulations are, so that your case can be appropriately presented to the judge. Yes, ma'am.
How many years of work history do you have to apply for this? Because in my case, I was a stay-at-home mom, and I went back to work, and I worked just under 3 years. I'm not technically fired from my job yet. I'm just on leave.
So the question, okay. The question was, how many years of work experience do you have to qualify for the program? And that's an excellent question. So there are 2 disability programs. One program is called SSI, which is Supplemental Security Income. SSI is the needs-based program. It's also known as a welfare program. And to qualify for SSI, you don't need any work history. The only requirement is that you meet the financial guidelines. So if you are an individual, if you're not married, you cannot have more than $2,000 in assets. That does not include your house. That does not include one vehicle. But any bank accounts, 401ks, land, motorcycles, anything is an asset. So if you're an individual, it's $2,000. If you're married, it's $3,000. So they're very strict on the requirements in terms of getting SSI. Now, SSI pays a benefit amount of $733 per month. And it also comes with Medicaid health insurance. Now, Medicaid is not widely accepted. It can be quite difficult to find a doctor who will accept Medicaid health insurance, but that is the program or the benefit that comes with SSI. The other program is the Disability Insurance Benefits Program. Now, that is the program designed for working individuals. And what happens is when you are working, you'll see on your paycheck you pay your FICA taxes. Well, part of the money that you pay for FICA taxes goes into Social Security disability. So that basically earns you quarters of coverage so that if you become disabled, you can receive the benefits. Typically, you have to work 5 out of the last 10 years to have enough quarters of coverage to be eligible for the DIB, or Disability Insurance Benefits Program. Now, for younger individuals, and when I say younger, under 30, you don't have to have as many quarters of coverage, or, it's a little different in terms of the time frame that you have to work. But for most adults, it's 5 out of the last 10 years. Now, the benefit amount that you receive for the DIB program is based off of your contributions to the system. So everyone's benefit amount is going to be different, but the maximum is around $2,600 per month. DIB benefits also come with Medicare health insurance, which is much more widely accepted, and that's the health program available for people who are 65 and older. Yes, ma'am.
If you were on disability, Social Security disability, when you reached say 65, you would not be entitled to just Social Security?
So the question is, if you are receiving Social Security disability benefits and you reach the age of 65, and I'm going to add to that, and or full retirement age, would you still be entitled to Social Security? What happens with disability is once you reach your full retirement age, which varies depending on what year you were born, the benefits that you were receiving for Social Security disability convert to Social Security retirement benefits. So your entitlement to disability ends basically a month before you reach your full retirement age. Okay? So your disability payments would end and your Social Security retirement benefits would kick in. So you're not going to see really a difference. It's just going to come out of a different pot of money. Yes, ma'am.
Continue on that. I am Social Security disability approved. Was with retroactive 6 months of SSI, and then after 2 years of disability became eligible for Medicare. My question is, when I reach retirement age, I understand that because I've not been married and was married for over 10 years, that at the same time that it starts pulling from my Social Security, same amount, that I'm also eligible to apply through my ex-husband. And I can hope he contributed more.
So,
is that still?
So yes, let me first repeat your question. So the question was, if you're receiving Social Security disability benefits and you have an ex-spouse who has contributed to the system, can you receive their benefit amount, and I'm paraphrasing for you, once you reach the appropriate age? And the answer is maybe. Social Security is going to compare your benefit amount to your ex-spouse's benefit amount and see which one is higher. So you're not going to be able to stack the benefits, but you're going to be able to receive the higher of the two. And it's not necessarily going to be at your full retirement age. Essentially, once you reach the age of 62, assuming that your ex-spouse is also 62 or older, then at that point you can start receiving their benefit, or receiving benefits from their work history.
I need to mark my calendar for it. That's not something that's automatic.
The question is that something that she would need to mark her calendar for? And I would say absolutely. Now, it should automatically happen, but you need to mark your calendar for it. Contact Social Security at age 62 and see what would give you the most in terms of benefits. But that is something that they will look at, yes. Yes, ma'am.
I'm on Social Security disability, and when I reached 62, I was married for a I don't know if I explained that correctly.
You did. So the question is, she is receiving Social Security disability benefits, and she is divorced, and she wants to know if once she's 62, if she will receive any of or any benefits based off of her ex-husband's earnings. And so that actually piggybacks off of the last question. And yes, you want to contact Social Security to figure out which would yield you a higher monthly benefit amount. So it is possible that if your ex-husband's work history and earnings were substantially higher than yours, that you may benefit from receiving off of his record instead of your own.
But if my benefits are more than his, there's nothing?
If your benefits are more than his, then you're receiving the most that you'll get. And I think there's a question back there.
Yes, is it on the Social Security website, depending on what you made before you became disabled, what you would be eligible for with SSDIB?
So the question is if Social Security's website can provide you information about your earnings record and an estimate as to what your monthly benefit amount would be if you're disabled. And the answer is yes. I believe it's myssa.gov, and you can look at your earnings record, and you can also get an estimate of your benefit amount. Now, you can also call Social Security, and they can look it up and give you an estimate of your benefit amount as well. Now, one thing that I do want to mention about the DIB benefits, now this is the work history program, is that one of the benefits of that program is that if you have contributed enough and you have minor children, your minor children may also be entitled to receive a check if you become disabled. So that's something that can help a household out immensely. Yes, ma'am.
What is the age of minority considered in that situation?
So under the age of 18. So if you're, I'm sorry, the question is what is the age considered to be able to receive benefits for your child? So if your child is under the age of 18 and you are also disabled and you are also entitled to receive the DIB benefits, what you'll have to do is you'll have to actually go down to Social Security and you have to fill out an application for your minor child to also receive the benefits. But that is after you've been found to be disabled. Yes, ma'am.
How do they base, if you had a minor child, how do they base that, what that child would be?
So each of us who is, I'm sorry, let me repeat the question. The question is how do they determine how much your minor child would get if you are entitled to disability benefits? So each of us has a family maximum. So we have the benefit amount that we are individually entitled to, and then there's a family maximum. So typically what happens is that your minor child is entitled to up to 50% of your benefit amount. But like I said, each of us has a family maximum. So if you have, for the sake of example, let's say my benefit amount is $1,600 a month, and my family maximum is $2,400 per month. And I have 2 minor children. What happens is there's $800 left there that will be divided between my 2 minor children. So they will each get $400 per month as long as they're under the age of 18 and I remain disabled. Okay. Yes.
One of the things when you handled my claim was that came up was gap in care, and I really didn't understand it because as a person with hypersomnia, you go to doctors forever and you don't get an answer, or they tell you to lose weight or get some more sleep or take some vitamins. So like I stopped going to the doctor because the copays are costing more than the benefit is going. So I had lost about 1.5 years of this program. So maybe if you could just explain what that is.
So the question was about a gap in treatment and essentially what effect a gap in treatment has. And the example that was given was going to the doctor, not really getting any results, being told take some vitamins, and so, sometimes financial constraints are there. You can't afford to pay your co-payments, so you're not able to go to the doctor as often as you need to. What impact does that have on your case for disability? And the answer is, it depends. It depends on how long you have to go without treatment. If you have to go for a considerable amount of time, let's say you go a year without any treatment, what happens is during that 1 year period of time, even though you had treatment prior to and you have treatment after, Social Security has no idea what was happening to you. Did you get better? Did you get worse? We don't know. There's nothing in the medical records which would indicate a continuation of symptoms or a worsening of symptoms. So the general school of thought is, since we don't know, you got better. And until the medical evidence reappears to show you're having these symptoms or that you had a worsening, then that's the time frame that we're going to look at to establish a disability. So a year is a long time. For many people, it may be 4 or 5 months. Well, that's not too bad. I wouldn't be concerned if your gap is 6 months. But if we're talking about a year and there's been no treatment, then that will have an impact on the case because there's just no proof that you were unable to work during that time. Yes, Sam?
To piggyback off of that question, hypothetically, you have been out of a doctor's care for a year. You go back to the doctor and you have them document in the medical record that indeed you have not been able to work for the past year. Like, if that becomes part of the medical record, is that helpful?
So the question is, if you've had the gap of 1 year of treatment, you return to the doctor and you discuss with the doctor and have them document the fact that for the last year you weren't able to work and you weren't doing well, would that be helpful? In most cases, no, because there is not going to be any proof that that was indeed the case. The doctor is just, and really the doctor doesn't have any proof to go on either. So
it's only what we tell them. And so if we say it to ourselves and we don't see the doctor, it's still true, and what we tell the doctor, and then it becomes a truth that is accepted by the Social Security Administration. It still happens.
So the comment was
to a doctor makes it believable.
Talking to a doctor about your complaints, it offers some authenticity because what happens is it ends up in your medical records. Anything that is not in your medical records, it's like it doesn't exist. So one of the most important things that you can do as a patient is to talk to your doctor. Your doctor has no idea what is happening with you. Your doctor has no idea whether the treatment is effective if you don't communicate with them. And Social Security has no idea. So if Social Security has no idea, they're going to assume that you can work. So it's important to be very verbal with your doctor or nurse or whomever, even if you're not going to a specialist. One of the issues that comes up quite often is that people cannot afford to get to a specialist, so they'll go to their primary care doctor who will try their best to help with their symptoms. And that's fine, because the primary care doctor is still going to document, Jan was here today. She's reporting she's sleeping in excess of 14 hours a day. She's still exhausted. I've tried to give her Provigil, and we've tried Adderall. And so the primary care doctor can still document all of the complaints that you're having, and that's what's most important, is that there is proof that you are struggling and that you're not able to do even the things that I take for granted, like, washing the dishes and cleaning my house and being productive for, 8 hours during the day. So the key is documentation. It does not matter who that documentation comes from. It's always helpful if it's from a specialist. If it's from an expert like Dr. Rye, that's always very helpful. But everyone doesn't have the opportunity to do that. So do not be discouraged if you can't get to a specialist. Just make sure that you're going to a doctor.
One thing that I'd like to add is know what's in the record that they're sending, because a lot of times doctors will send something and it's not what you said. I've gone in and I said, I'm tired, I can't do the dishes, I don't have the energy, which equates to I lack the motivation. And they write it down. It's not what I said. And when they present those records, they end up hurting me.
So the comment was that you should be aware of what is in your medical records, because sometimes when you go to the doctor and you report specific complaints, those complaints don't end up in the record. Instead, it may be someone else's impression of what you said, but it does not accurately reflect what's going on with you. And I couldn't agree with you more. What happens is, of course, Social Security gets those medical records, and it says, patient is just not motivated. Or it may say, patient says, she's feeling fantastic, and she can run a marathon. And what you may have said is, I used to be a marathon runner, and I can't even walk down the street anymore without feeling overwhelmed. And sometimes things are misinterpreted. But again, Social Security can only make decisions about what they see in the medical records. Now, the benefit of having an advocate once you get to a hearing is that there can be some discussion about that particular visit note. Hopefully that visit note is not consistent with anything else that's in the record, and it kind of jumps out as something that's a little bit odd. All of a sudden you ran a marathon that you never ran. But those things do happen. I mean, we are all human beings, and mistakes can happen. But the important thing is that you address those particular notations that can be very harmful to the case. Yes, ma'am.
Once you're approved for disability, is that forever, or do you have to reapply so often? Or, I'm worried, when I was working, my bad days, my horrible days were every single day. Now that I haven't been working for a couple of months, I have less horrible days, but still not great days overall. If I was approved, is there some point where it's like, oh, well, she can go out and cut the grass, or she can keep the house tidy finally? Okay, now let's send her back to work.
The question is, once you are approved for disability, are you approved forever? Or is there a reapplication process? So each individual that gets approved for disability has to, unless you're very close to retirement age, you will have to at some point undergo a disability redetermination. And so they will typically do it at either 1, 2 years, sometimes 3 years, 5, or 7. It just depends on your particular case. So for each individual that's approved for disability, expect that at some point in the future, you are going to be reassessed by the Social Security Administration. Now, if you are a younger individual, in your teens, 20s, 30s, expect that that's probably going to be in a year or 2, possibly 3, but usually 1 or 2 years, that they will want to reevaluate you. And so what that involves is another medical records review. And if you have been doing better, and better is a relative term, you want to be specific about what better means to you when you go to the doctor. A good example would be, I've been out of work now for 8 months. I do find that I have more energy, which allows me to be productive for maybe 2 hours during the day. And then I need to go and rest. As opposed to, I've been out of work for 8 months. I have so much more energy, and I'm able to get my house clean and cut the grass. Those two examples suggest very different things. And if you're reviewing someone's file and you see that somebody is better and they're able to do, their household chores and cut the grass, then it is reasonable to believe that there has been enough improvement which would allow that person to return to work. So unfortunately, you do need to be very specific, because Social Security, they do have a huge task on their hands in deciding whether or not an individual can work. And I'm sure all of you have seen some of the news stories, about people who are out, pushing boulders, who are receiving Social Security disability, and that's more the exception than the rule. I mean, most people who are receiving these benefits legitimately are not able to work due to a physical and or psychological condition. And the psychological conditions are just not easy to see. You cannot see that someone is having some serious cognitive problems. So what always looks good isn't always good. And I'm sure many of you know that, because you all look fabulous and healthy, but you're dealing with significant struggles. Yes?
Once you're on disability and you're not supposed to be working, is participating in a clinical trial going to affect them receiving payment down the line?
The question is, once you're receiving disability, is participating in a clinical trial going to affect your benefits down the line?
Because they do give you payment.
Because you do receive payment for the clinical trial. So the answer is no. First, let me say this. You can technically be disabled and work. There are plenty of people who are disabled and work part-time in some limited form or fashion. So to be disabled does not mean that you're bedridden. It does not mean that you can't make it through a day. It means that you cannot, on a consistent basis, work full-time. So part-time work is acceptable. Social Security does have rules in terms of, they look at your actual earnings to decide whether you've made too much money in working part-time. So those rules can be a little tricky. But, for people who are able to work 10 hours a week at Kroger, bagging groceries, Social Security, you're still falling within their guidelines. They want you to work and be as productive as you can, and they really want you to be able to return to work. So there are rules that actually encourage people to return to work without penalty, to just try it for a few months. It's called a trial work period. And the rules get really tricky and confusing about the trial work period. But what I want you to know, generally speaking, is that you can return to work for 9 months. They don't have to be 9 consecutive months. And you can make $1 million a month. It doesn't matter how much you make for those 9 months, because it's without penalty to test your ability to re-enter the workforce. So each person that is disabled is entitled to a trial work period. Some people will use it. They'll find a job that works for them, great supervisor, and they're back at work and they don't need the benefits anymore. For a lot of people, they want to work badly. They say, let me try it, and unfortunately it doesn't work. So the benefit of the trial work period is they tried it, they lasted 2 months, it didn't work out, they still get to receive their benefits. Now, to kind of finish answering the question, if you're involved in a clinical trial and you're receiving payment, it's probably not substantial. You're not going to be receiving $900 a month, doing clinical trial work. But I would keep documentation of what you're receiving for the clinical trial, just in case Social Security has any questions about it. You're not working. You're receiving treatment. You're doing some experimental treatment. So that's not work. And just keep your documentation just in case there are any questions later. But if for some reason you receive, let's say, $5,000 for this clinical trial, I would be proactive and contact Social Security and say, I just want you to know, here's the pay stub for this clinical trial that I'm participating in. I am not working. This is a clinical trial. And that way you cover your bases. Yes, ma'am.
On that same thing, first of all, thank you for asking and answering, because I had a hard time getting a clear answer from Social Security on that. There was a lot of confusion confusion. Everyone's trying to do the best they can, but there was a lot of confusion on it. One thing that they did mention is that while they won't count it as income, that in fact, depending on your tax situation, where mine is such that my income, I actually no longer currently file income taxes. But in fact, depending on the amount of money earned at the clinical trials, there may be, that may have to be claimed on taxes. Now, having said that, IRS cannot tell you necessarily if you will be taxed on it, because apparently from the information that was shared with me, they don't get their tax information until December before the tax year you just went through, so you can't even be proactive and find out, okay, what kind of plans do I need. So if you have any connections or information that might be enlightening on that, otherwise I think what you're saying applies to just be proactive and check and keep them in the loop and let them be aware.
So the question was whether or not participation in a clinical trial may have some tax implications with the IRS. And it may. What I recommend is that you consult with a tax professional. What probably will happen in that case is it's going to look like your 1099. So it'll be self-employment earnings, and it can be of varying amounts, but it may be high enough where you do have some tax obligations. So definitely talk with a tax professional. They can guide you in terms of what you may need to do to prepare for any response that you may get from the IRS down the road. Yes, ma'am.
When you're applying for short and long-term disability benefits with your employer, does the time frame that you have to get, you have to submit information where you're recertified? With mine, it's every 2 months, so they approve me, and then 2 months later, they're like, well, they approved me for Retroactive Hypersomnia. 2 months later, I still have it. They denied me. Same information, same doctor, same person. No big change. And for long term, it's the same way that they every 2 months, or it just depends on what company.
So the question is about short and long-term disability benefits and recertification. Each company has their own policy as to how long they will pay your benefits or approve you for before you have to recertify and get another letter from your doctor, have your doctor fill out another form. And that could be every 2 months, that could be every 6 months, or a year even. It just depends on the particular long-term disability carrier. Now, if you are denied for benefits, short or long-term disability, that's not my area of specialty, but if anyone wants to talk to me afterwards about contacts in terms of getting some help, that will be important. One thing that you should know about short-term or long-term disability benefits is the receipt of those benefits can be helpful for your Social Security disability case, because your doctor is having to fill out forms to certify, what your impairments or conditions are, and basically whether or not you can work. Can you do your job? So that can be good evidence to use for your Social Security disability claim. Now, one thing to be aware of is that there are differences in Social Security versus long-term and short-term disability about what it means to be disabled. Most short and long-term disability insurance carriers will say you're disabled if your condition, at least the first 2 years, keeps you from doing whatever job you were doing. So they're only worried about your ability, in most cases, to perform that particular job with your conditions. Social Security, on the other hand, especially if you're under the age of 50, they want to know, can you do any job? So you may not be able to be a bookkeeper anymore, but you might be able to take tickets at a movie theater. And in that case, you're not disabled from Social Security, but you are disabled from short-term or long-term disability insurance. So there is a big difference in what their regulations state about the meaning of disability. Yes?
So you said something about psychological conditions. So, a lot of us suffer from depression and anxiety with this because it's really depressing not to be able to do our regular lives. When you are applying, do you list everything that's going on, like most of the stuff that you're telling me, but let's say of other health conditions, do you put all of this stuff together and you're like, here's this great bag of things I have?
So the question is, when you're applying for Social Security, even though hypersomnia may be your primary impairment, if you're dealing with other conditions such as depression or anxiety, do you also include those conditions in your application? And the answer is absolutely yes. Social Security is to consider you as a whole. Every impairment that you have that could affect your ability to work. And the way that they look at it is like this. Sometimes the depression and anxiety by themselves may not be disabling, but the combination of the hypersomnia and the depression can completely keep you from being able to function as you should on a daily basis. So they need to know every condition that is impacting your ability to work. Also, in considering those conditions, Social Security can decide to send you out to meet with an independent physician for a physical or an independent psychologist for a psychological evaluation. So it's important that they know up front what all of the conditions are so that they can give a more accurate prediction as to what you can do. Also, medications. Medications that you take for different conditions, some of the side effects are they'll just wipe you out. So it's important that they know everything that you're dealing with, and the severity is something that can be determined later, but they definitely need to know everything, every condition that you're dealing with. Yes?
I guess a two-part question. What are your recommendations for those of us who may be married where one of us would be looking for potentially disability rather than just regular earned income individual? And then does that advice change depending on things?
So the question is, if there are two individuals, married individuals, one person is not able to work because of their impairments and the other is able to remain gainfully employed, does that affect your eligibility for disability? And the answer is it can, only if your spouse who is not working doesn't have the work coverage or quarters. So if your spouse is only eligible for SSI, let's say your spouse has been a stay-at-home mom, and now she's just not able to work at all. She is only going to be eligible for SSI. So how much money you make can make her ineligible. So, if you're making $60,000 a year, she's not going to be eligible for SSI. SSI, again, is the welfare or income-based program. But if your spouse has worked and has worked 5 out of the last 10 years, it doesn't matter how much money the household makes, because the Disability Insurance Benefits Program does not look at income or assets of the household. You're eligible because you worked and you paid into the system. Any billionaire is eligible for disability as long as they worked and paid into the system. Yes?
On that connected note, I'm only familiar with my experience. So when I was approved SSI was retroactive to 6 months. I don't know, I said silence when you turn your phone to when my last day of work, when I first started taking family medical leave consecutively. Is SSI always 6 months retroactive in those cases, or does it go back?
So the question is about retroactive pay or back pay, as we like to call it. And essentially the way that the program works is this. Once you apply for SSI, if that is the only program that you're eligible for, SSI payments can be made from the date of application forward. So if you wait 2 years to apply for SSI, you can only get paid back to the date that you applied, even though you were disabled 3 years ago. For the disability insurance benefits program, if I stopped working in July of 2015, but I did not apply for disability until July of 2016, benefits can be retroactive up to 1 year. So they can go 1 year prior to the date that you apply, only for the DIB program.
DIB, that's what I think of as Social Security Disability Pool.
DIB is the Social Security Disability Insurance Benefits Program, so for working people. So that program gives you a lot more flexibility because you have paid into the system.
So even if it takes you 3 years to go through those 3 steps, you'll only back pay for 1. Is that correct?
So let me walk you through. The question is, if it takes you 3 years to get to a hearing and get approved, will you only be paid back 1 year? And the answer is no. They are looking at your date of application. So if I applied January 1st of 2016 and I finally get to a hearing in January of 2019, they can pay me back, and I was disabled as of January 1st of 2015, I'm going to get 4 years worth of back pay approximately. So you are not penalized for the long wait. What's important is, number one, when did you apply for disability? And number two, when did you become disabled? So, as long as you don't wait too long to apply, your back pay could be for several years. Yes, ma'am.
How do you suggest defining when you became disabled? Because that was definitely a challenging thing on the paperwork, and I am approved SSD but did not have an attorney disability caseworker, but we struggled because so many of us with this, we don't have a definite date of when we became disabled. It seems to be an accumulation and then not being able to function. And I know diagnosis dates, become one thing, going out on family medical leave. And so I was trying to find a way to ask you that because we based it on my official diagnosis date, but I was technically disabled prior to that.
So the question is, how do you determine what date you became disabled? For many people, there are an accumulation of symptoms. There may take maybe years before you actually get an official diagnosis. So how do you figure out when your disability began? The first thing is, if you're still working, you don't meet the definition of disability. So for most people, they are going to use the date that they stopped working, or if there's an accident, they may use the date of the accident. But it cannot be when you were still working 40 hours a week. Now, that date, though, is a flexible date. When you apply, you may indicate that you became disabled, the day that you went on short-term disability and you haven't worked since. And that's fine. But Social Security, when they review the records, they are still looking to see, number one, are you disabled? And if you are, is there a date and time which the records support that you were not able to work? And a judge may find that it wasn't when you went out of work, it was, 6 months later when you went to the doctor and the doctor said, she's now at the point where she's sleeping 15 hours a day. The judge may say that's the date that she became disabled. So it is a flexible date, but it cannot be while you were still working full-time. And it can be changed. It can be easily changed. So don't stress about that date. Just know that at the earliest, it's most likely going to be when you stopped working. Yes, ma'am.
Okay, my instance, I have a child who's 12, and we're in the process of getting all these diagnoses, educational-wise, and with the narcolepsy and the sleep apnea. Now, how do I handle that when it gets to a point right now with the meds that it's not working, and we get to the age of potentially maybe not going to college and stuff that I need to apply for Social Security, or does she come under our insurance and then keep on? So that's the dilemma we're having right now.
So the question is, she has a child who has some problems with narcolepsy and possibly some other impairments, and they are at the point now where they're trying to get a proper medication regimen, and they're looking to the future to figure out when would be a good time to apply for disability if they don't believe that the child would be able to work or go to college or be productive in Social Security terms. And the answer to that is it depends. If your child is not eligible for SSI now because of your household income, then you can't apply for disability until the child is 18. Because right now they look at household income to determine whether or not the child is eligible for SSI. But if, in the future it looks like despite medication and any other sort of treatment that your child is not going to be able to work, and that's really how you need to look at it. It's not so much about college, even though that may be the route that you want your child to take. Social Security cares about working only. So if it looks like your child would not be able to work full-time because of the narcolepsy, then at age 18, that's the time when you want to apply, because they no longer look at the household income. They look only at the child and what assets the child has. But that would include college funds and any bank accounts, so just keep that in mind. Did that answer your question?
Yeah.
Okay. Yes.
What's the cost of using a lawyer? Does it change if you go through all of the denials and then just have to for the hearing? Does it change, and is it different by state to state?
The question is, what is the cost for using a lawyer? Does it change depend on what stage of the process you're at? Does it change based on what state you live in? And the answer is that Social Security is a federal program. And so they regulate the payment to attorneys, which is a great thing. What Social Security's rules say is that, number one, attorneys have to be paid on a contingency basis. What that means is an attorney cannot be paid until he or she wins the case for you, and you have to be entitled to back pay or past due benefits. And then, if those two conditions are met, Social Security will pay the attorney 25% of your back pay, but it is capped at $6,000. So no matter what stage of the process you're in, it doesn't matter. You're not paying a retainer like you would if you go see, a family law attorney. You're not paying the lawyer anything in terms of attorney's fees when you hire them, no matter what state they live in, no matter where you are in the process. Social Security pays the lawyer directly out of your back pay after they have won for you. So it's not costing you anything to get a lawyer. It is only costing you to pay them after they've delivered for you and won your case. And again, the maximum is $6,000. The minimum is $1. So it just depends on how much money, or it could be nothing. There are cases that I have where I've won the case for my client, but they don't have any back pay. So my attorney's fee is $0, but my client got their benefits. So that's how the program is set up. It's to help claimants to make sure that lawyers don't take advantage of you and say, oh, sure, I can help you for $10,000, and then you lose the case. Yes, ma'am.
So, what if somebody comes to me with medical information and it's theirs, and you don't think that you're going to be successful in representing them?
So the question is, what if someone comes to me with medical evidence and it's very thin, and I don't think that I would be successful in representing them? My answer which may depend from other attorneys, is I would let you know that. I would explain to you, we would talk about the medical, what it says, what I think it means, and what I think Social Security is going to do in response. So if I don't believe that I can help win your case, I'm going to tell you that up front. And I'm going to make some suggestions to you as to things that you may do because you have an impairment and you just need to strengthen the evidence. And that may be, directing you to some local clinics in the area, or making some other recommendations so that you can try to get the help that you need so that you can be successful. Yes, ma'am.
Do you have time to touch on trust? Someone had brought it up to me recently, and again, I'm someone who's Social Security disability approved, limited income, creatively, financially challenged, and a lot of our medication is not insurance friendly. And so someone was making a creative suggestion that if I had someone in my life who was willing to help support like my medication costs, that there was a way to do it where it would not interfere with it being considered income. Is that the trust issue that you're talking about, that they could put money in trust that would be earmarked to pay for things like that?
That is the question is about a trust issue, and I'll talk to you about trust after, if you'll stay after for a couple of minutes, because that's a completely different animal, so to speak. So we'll talk about that afterwards.
Thank you.
Yes.
I have a question about the attorney fees. If you live in one state, Florida, and you move to Georgia, can you keep your Florida attorney, or do you need to have an attorney in Georgia? That's the first part of my question. And the second part is, if you do have an attorney there and then you moved here and you go in front of for your hearing, I heard you say that the max is $6,000 for the 25. Is there a possibility that it could be more?
So,
For the two attorneys?
so the question is this: if you have an attorney, let's say you live in Florida, you have an attorney in Florida, and you move to Georgia. First part of the question is, can that Florida attorney continue to represent you in Georgia? And the answer is yes, because this is a federal program, as long as that Florida attorney wants to continue to represent you in Georgia, because that is going to mean that that attorney will have to come to Georgia for your hearing. The second part of the question is, if you had a Florida attorney, you moved to Georgia, and you got a Georgia attorney, and you were approved for benefits after hearing with the Georgia attorney, do both attorneys get paid? Is the $6,000 for each attorney, or how does that work? So in that situation, what happens is when you have an attorney and you retain another attorney, Social Security is supposed to catch that, because you can't have two attorneys representing you at the same time, because only one attorney can get access to your file and be associated with it. So typically what would happen is Social Security would contact the Georgia attorney and say, did you know that Ms. Jones is currently represented by, another attorney? The Florida attorney needs to withdraw from your case. And this is where things get a little tricky. The Florida attorney has worked on your case. So it is up to the Florida attorney as to whether he or she wants to still be paid for the work that they have done. If they do, then what they'll do is they'll send a withdrawal letter into Social Security that says, I'm no longer representing Ms. Jones in this case. However, if Ms. Jones is successful in receiving benefits, I would still like to get my fee. Fast forward, you go to a hearing with your Georgia attorney, and the Georgia attorney is successful in getting you your benefits. Now there is a pot of money here, $6,000, that is available for one or both attorneys, and essentially each attorney would have to file a fee petition with Social Security and say, well, I did this work, says Florida attorney. And Georgia attorney says, hey, I've been on this file for a year and a half. I took her to the hearing. We got all this information. I'm entitled to this, and the judge is the decision maker. So the judge will decide who gets paid what money. So it becomes a little bit of an issue, but it does happen. And then there are attorneys that will simply say, I'm withdrawing from her case. I understand she's moved. I'm waiving any right that I have to fees. And then you're free and clear to find your Georgia attorney who will be entitled to the full fee for their work.
Thank you. And the last question I have regarding this is, when I was awarded Social Security disability, the judge was adamant about putting the time frame as to both attorneys and fees. 1 year later, they're still arguing about the money, even though every document I received says that you've got 15 days to respond.
So the question is about the dispute in attorney's fees between the two attorneys. When Social Security judges make their decisions about, number one, whether or not you're disabled, you are given 15 days if anyone has an issue in terms of disputing the fee. And that's not a firm 15. There are notice requirements. So, the other attorney probably didn't find out about the approval until it could have been months later. So the 15 days wouldn't have given that attorney an ample opportunity to respond. But yes, it can drag on for quite some time. It is not uncommon in terms of fees. So it will eventually get resolved.
So even if there's problems about the attorney fees, that impacts, even though fees have been approved, that still impacts their ability to...
So the question is, if there are disputes about attorney's fees, can that impact the claimant's, I'll say, receipt of back pay? And it can. It should not, but it can. At this point, the claimant has been approved. The issue is over the attorney's fees. But yes, that can affect the claimant's receipt of back pay, because the back pay and the attorney's fees are, at least in a SSDIB case, the Working Benefits Program, they're processed out of a payment center. And so the payment center is responsible for paying the attorney, the attorney's fees, as well as the claimant the back pay. And they want to make sure that they're not releasing any funds to the wrong place. So sometimes they'll just wait until they have resolution as to who they need to pay. Yes, ma'am.
Did you say that the attorney's fees automatically 25% or is it up to 25%?
So the attorney's fees are 25% of, I'm sorry, the question is, did I say that the attorney's fees are automatically 25% or up to 25%? The attorney's fees are 25% of the past due benefits up to $6,000. So it's whichever is less. And again, attorney's fees can be zero. Anywhere between $0 and $6,000. Yes.
What's the typical amount of time that someone should expect to put into trying to seek disability?
The question is, what is the typical amount of time that someone should put into receiving disability? And I'm not sure what you mean by that.
Expect to expend with the same attorney or with others in pursuit of a disability claim.
And the question is about how much time an individual should expect to receive with others in pursuit of a disability claim. Correct?
Yeah.
And I think you're asking how much time and effort it would involve for a claimant to apply. So the answer to that is it depends on whether or not you're applying on your own or whether you have an attorney and what that attorney will do for you. If you are applying for disability on your own, then you are responsible for filling out the application, for getting the paperwork into Social Security, for filling out all of the, they send what's called a function report about what you do during the day. They send out a work history report. So you're responsible for basically interpreting everything that Social Security needs and supplying it to them. If they have any issues with your case and they can't get a hold of a doctor that they need or they have a question, they're going to call you. So it could involve a significant amount of time on your part, and it's a very overwhelming process for most people. If you have an attorney, there are some attorneys that say you have to get denied first before they'll help you. At our office, we start people off at initial. So what we do is our clients, if they can, they come in the office to us, and we talk with them, and we fill out the application, and we guide them through the process. We are the point of contact for Social Security when they have questions, or if our client has questions. You know, I know it can take 3 to 6 months at initial, but I just want to know what's going on. Well, that's where we call Social Security and we find out what's going on. Or if Social Security has an issue that needs to be resolved, then they'll contact us. So it just depends on who you're working with as opposed to whether or not you're doing it yourself. If you're doing it yourself, it can be quite overwhelming because there's a lot of paperwork to do, and the process is completely foreign to you. And the process itself, usually these days we're seeing up to 3 years from the time that you file the application until you get to the judge. Yes?
I was awarded Social Security benefits. I guess I could expect to be reevaluated at some point. Do I go back to you for that? Or do I do that on my own?
So the question is, if you've been awarded Social Security benefits, you can expect to be reevaluated. Do you need to go back to your attorney for that? And the answer is no. So Social Security is going to do that on their own. So they're going to request their records, and they're going to do an internal evaluation just as they did when you applied. You will need your attorney if they come back and they say, we think your disability is ended, we're cutting off your benefits in 30 days. Then you need to call your attorney and say, help. I don't want to lose my benefits. I have not gotten any better. What do I need to do?
To piggyback on that question and maybe to clarify, because again, I operate from what I know and it may be different. When you have that recertification with Social Security, which they determine, I understand, mine happened to be at the 2-year mark, happened to also coincide with becoming Medicare eligible. And I presume all that happens at the same time, but I suppose if someone doesn't have a review until the 5-year mark, does Medicare also travel with that, or what is the time frame?
So the question is about Medicare eligibility. What is the time frame until you become Medicare eligible? So Medicare eligibility, unfortunately, you have to wait 29 months from the date that you become disabled, according to Social Security. From that date, 29 months later, then you are entitled to Medicare. So in your case, it was just a coincidence that they were doing a review around the same time. But, for everyone else, it's just a 29-month waiting period. And if you have, been out of work for a year and you applied for Social Security disability and you waited 2.5 years before you got approved, you're going to be Medicare eligible already. You just didn't have the approval. So for some people, there is no official waiting period because it took so long to get through the process. But if Social Security determines early, or if a judge says, this new evidence shows that you became disabled today, then you have to wait that 29-month period.
Medicare, not Medicaid.
That's for Medicare. So with Medicaid, and thank you for clarifying that, with Medicaid, as soon as you're entitled to SSI, so from the date that you apply going forward, whenever you became disabled according to the judge, Medicaid starts at that same time. So as soon as you're disabled, if you're SSI eligible, you are Medicaid eligible as well. Yes.
Add-on, they also made my Medicaid retroactive because they didn't know what to do with that part of Medicaid itself. The office, they're not familiar.
So the question or comment is about making Medicaid retroactive, and that will happen. So again, if you've waited for a hearing 2 years, and Social Security says yes, you became disabled on July 15th of 2015, that Medicaid eligibility is going to go back to that same time that you became disabled. Yes, ma'am.
So if they make Medicaid retroactive, would that mean that you would get a refund of all of the co-pays and all of the out-of-pocket expenses that you, like, what effect would that have on anything?
The question is, what effect does the retroactive Medicaid, and I'm going to throw Medicare in there as well, eligibility have? Would you receive a refund? Would you, because you paid co-pays, what would happen? The answer is, I don't know. What you would need to do is get that information to the billing offices at the doctors and see whether or not, any adjustments can be made, but I don't know whether or not that's something that you can reasonably expect to happen. Yes?
Well, I actually function as a medical billing, and since there's a time frame on filing for bills, most of the time you need to patch that already, so they couldn't go back and rebill it.
So the comment was from a medical billing expert that there's usually a time frame that adjustments can be made, and for most people they're going to be outside of that time frame. Any other questions? Oh, I have one more. Okay.
No question, but a comment. And what you were saying, I haven't met this person. She's my attorney. I guess it was one. It took me 5 minutes. Started in South Carolina, another attorney, and when I moved here for grad school, he said that he didn't have some license practice in the law, even though my current living here. Finished it and it seems like right within last July or somewhere around there. So I didn't have to go to court. It was fine. So I did her assistance and got it really good. So I think having an attorney and also some in-depth information is very beneficial because I had to do all of that.
All right, thank you. Now, I did not pay her or ask her to come in and make that comment, but
I'll
yes.
piggyback on that one too, because I know there's a few people in here that aren't sure if they're ready to apply or haven't met with the state. Is she? To apply? No. I mean, when I was awarded it after years and denials, I remember walking out and her saying, "You won," and that was the most depressing time ever for me. And it wasn't a win. It was, and I was thankful. And that's what they really help, is they get them through that, because you're not mentally ready to concede to that. So a lot of times I wasn't giving 100% into my paperwork, or I wasn't really passionate about it, because it's not what I wanted, it's just what I had to do.
To have someone.
Yeah, to have somebody help you through that.
So kudos to you and other attorneys.
Thank you. Thank you.
And please, 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 you can remind people from somebody who has hypersomnia, again, it can't be said enough, I don't think, to help people understand that there is nothing out of pocket for people who need to pursue disability, that you get the expertise and it really doesn't cost anything other than a percentage of something that's being awarded that you don't have right now anyway, so you never miss it.
I really think I would have missed cutoff dates and forgotten to put forms in when I was supposed to.
That
do that
function
constantly.
alone.
Yeah, so it helps.
Thank you. So yes, just a reminder, and just to let everyone who's watching know, again, you do not have to come out of pocket to pay an attorney. The attorney is paid only after they win your case for you and if you're entitled to back pay. So it's not costing you anything, but you need the expertise of someone that you can trust to advocate for you, who understands the rules, who can explain to the judge, because the judges are not going to be exposed. They're not going to have any exposure to hypersomnia. Sleep disorders are just not something that judges see very often. So it's important that you have somebody that's willing to invest the time to not only educate themselves, but to also pass along the information that the judges need to make a decision, because there are a lot of, stereotypes out there. And, I had a judge say to me one time during a hearing, well, I get it, she's sleepy. Well, if only that were the case. I get sleepy too. That's not what the issue is here. But I'm sure you're all familiar with the level of misunderstanding that comes with a sleep disorder. And so it's just important to have someone who is willing to advocate for you and make sure that you don't miss deadlines, and make sure that you can get through the process so that you can get your day to be with the judge and understand and present your case. Yes, ma'am.
If you need an attorney, you would definitely get an attorney that was a disability attorney, not another attorney saying, oh, I can do that.
That's a great question. The question is, if you need an attorney, should you get a disability attorney or just any attorney that says, I can do it? You definitely need a disability attorney, someone that specializes in Social Security disability, because Social Security has its own set of rules and regulations. And if the attorney is not familiar, I came from an insurance defense firm. And so I was in the world of civil litigation, on the defense side. I knew nothing about Social Security's rules. I had to learn them all. And that, it requires a lot of time to learn a completely new area of law and all of the nuances. So definitely find someone who specializes in Social Security disability so that you can be represented effectively. Yes, ma'am.
To offer just clarity and understanding. I said it took me 5 years, but I originally applied under a mental health disorder. Didn't find out about the sleep disorder until 2014. So I did apply. First time I applied by myself. Second time I used an attorney. Then moving. But I had attorneys that didn't want to take the case because one, I'm learning from cases. So it was too young. And I kept saying 39. And because I went to the saying too smart, like if you didn't do that, it didn't work. And so I had to prove why I could be doing it and actually how I was being effective and effective by going to. But I was surprised I didn't have to go to court during this regular case. But during the first time I did, and I wasn't alone.
Translation, good support matters.
Good support does matter, particularly, and you bring up a good point. So Social Security disability is basically a retirement program. It's separate from retirement, but when you're disabled, you're retired at least for some period of time. That's how you're viewed, because you're not able to work. And so it makes sense that Social Security, the administration, they don't want to have 20-year-olds and 30-year-olds who are receiving disability benefits for the next 35 years when they can be working. So when you're a younger individual, it is much more difficult to prove that you are not able to work at all. I mean, you have a long work life ahead of you. And so you really need to have good, solid evidence supporting your claim. And it does make it difficult. There's some attorneys that will not work with younger individuals. But, a good attorney, it doesn't matter how old an individual is. It's what are you dealing with, and is it keeping you from working? Yes, ma'am.
I fall in the category. I'm 21. If there wouldn't be anything like, they don't want you to work, there wouldn't be any sort of help for if you could go to school, but you can't also work full time to support yourself. There'd be no financial support so that you could move on. So that you could have financial support as long as you're school full time, because I would like to be able to work. Like I have a master's and all that, but you can't, do full work and full school, but I also can't do part-time.
So that's a good question. The question is about school and working. If you're able to work or go to school part-time, or go to school full-time, but you're not able to work and go to school or work full-time, is there a program out there that helps you? And, there are some different schools of thought from the disability realm about working in school. Most people at Social Security, I think, would say if you can go to school full-time, you can work full-time. Now, I've been a student for many years, and I know that the two are not equal. It's not the same to go to school and be a full-time student and go to work and work full-time. But generally, that's the school of thought. And so Social Security, if you're capable in most cases of going to school full-time, they're going to say that there's some full-time work that you could do instead of. So they're not going to find that you're disabled if you're just not able to work because of school. Does that make any sense?
Kind of feel like I can't do full-time either. I take 3 classes.
Okay.
So I'm been in college for almost 4 years and still freshman credit. So it's just new to me. I'm just going to pay longer to do school. I should be graduated and have a master's degree, but that's not how the world works, right? So I'm forced to, but I support myself financially as well. So I have to pick to take the part-time work hours over the 3 classes I take. So even those sort of, I don't know, you can only handle part-time school. So I'm not doing full-time either or.
So are you working part-time and going to school part-time? So, that gets to be tricky, because what I think many people would say was, well, you could just pick one. I mean, you could just work full-time instead of going to school part-time. So they're not really looking at what your personal goals are in terms of your career. They are only concerned, if you're under the age of 50, can you do a simple job? Can you perform a job like being a ticket taker 40 hours a week? Does your condition allow you to show up every day from 9 to 5 and be a ticket taker? If it prevents you from doing that, then you need to be applying for disability. But if it's something that you could do, then Social Security is going to say there's work that she can perform. It may not be work that she wants to do, or work, it may be work that she's way overqualified for, but she can still perform some work. So that's the trick with a younger individual, is, they're looking at unskilled, very simple, basic jobs. And we can talk about your particular situation afterwards if you'd like to. Yes, ma'am.
Well, I have 2 questions, but one is related to this. Even if she can be a ticket taker and work 40 hours a week, that's not going to be enough to support you. So figure out.
So the question is, even if someone could be a ticket taker and work 40 hours a week, it's not going to be enough income to support them. I don't disagree with that, but Social Security does. Social Security believes that if you can work full-time, you can support yourself. And remember, SSI is the income-based or the welfare program, and it pays $733 a month. So in fact, the government is saying you can live off of $733 per month. And many people do. I mean, I'm not sure how, but many people do it.
Other question was, when you go to a hearing, is it always in federal court because of being Social Security, or would it be in your county court?
So the question is, when you go to a hearing, is it always in federal court, or would you go to your county court? So Social Security judges are federal judges. However, most of the courts, and I'll just speak from a local standpoint, most of the courts here, like in the metro Atlanta area, the hearing offices are not in the federal courthouse. There are a couple, like Gainesville, Rome, they're in the federal building, but if you have a downtown Atlanta hearing, you're not in the federal courthouse. But it is still a federal office, and all of those same rules apply in terms of no weapons and things of that nature. And you're going in front of a federal judge, and it is a courtroom. It's just not at the courthouse, not at the federal courthouse.
All of Social Security is directed right there where in this facility?
So in the in the Metro Atlanta area, there are 2 hearing offices. One is downtown Atlanta, and the other is actually right off of Claremont Road. So those 2 offices serve many of Metro Atlanta. There's an office in Covington, Gainesville, Athens, Rome, Macon. So that covers Metro Atlanta. And these offices are all hearing offices. So people who have their hearings will go meet with their judge at that particular location. And sometimes they'll also have a hearing by video with the judge. So it just depends on where they're going for their hearing. You're welcome. Any other questions? Yes.
How do people contact you if they want to get in touch with you to hire as an attorney?
Good question. So how can you contact me? If you want to talk to me, I will be happy to talk to you about your particular circumstances, specifically if you're in the Metro Atlanta area, because that's really where I travel to in terms of hearings. So my office number is 770-422-8111. You can look at our website, which is www.disabilityhelpline.com. And you can see more information about the process and our office on there. But you can give me a call. I'd be happy to talk to you about your particular circumstances and kind of give you some feedback as to where I think things would stand for you in filing. And if you're already in the midst of the application process, if you're waiting for a decision or you've been denied, if you've been denied, remember there are deadlines. 60 days. That's all you get to file an appeal. So you want to make sure that you don't miss any deadlines. And if you need to look for an attorney, that you give yourself enough time to find someone. Any other questions? All right. Well, thank you all so much for coming and asking great questions. And I will be around if any of you would like to talk to me about anything.